This is an appeal from the Court of Appeal, Criminal Division to the UK Supreme Court in the case of R v. Evans, Chedwin 2022. I am Ashley Horatio for the Director of Public Prosecutions. I will argue that, firstly, the Court of Appeal misinterpreted the application of the Youth Justice and Criminal Evidence Act of 1999 in this case. Secondly, the Court undermined parliamentary intent of the YJCEA 1999 by invoking Section 3 of the HRA 1998 to give effect to the defendant's fair trial rights under Article 6 of the ECHR. Thirdly, the Court's decision to expand the scope of Section 41(3)(c) in Evans undermines public confidence in the administration of justice. I will begin with a brief recap of the case facts and judicial history. Follow with a brief outline of the current law on admissibility of sexual history evidence. Present my key arguments, anticipated rebuttals, and then conclude with a brief wrap-up. Chedwin Evans was a professional footballer and one of the two defendants who stood trial for rape of a complainant X in 2012. Evans was convicted. The other defendant, M, was acquitted. Evans' applications to appeal his conviction were rejected before his case was referred to in the Court of Appeal by the Criminal Cases Review Commission. Fresh evidence had emerged that undermined the safety of his conviction. Counsel for Evans sought permission from the court to have the new evidence introduced since it related to the complainant's sexual history. The primary issue for the Court of Appeal was whether the evidence afforded a ground of appeal under Section 41 of the YJCEA. The appeal was granted, and Evans was acquitted following a retrial in which the evidence was admitted. The law reflects a tension between the interests of complainants, their dignity, and the effective participation of defendants relative to their presumption of innocence and fair trial rights. The Youth Justice and Criminal Evidence Act of 1999 governs the use and admissibility of sexual history evidence within a criminal trial. The legislation was designed in part to address this tension. Section 41 prohibits both evidence and questioning about the sexual behavior of a complainant unless a judge rules that it fits within one of the several specific gateways as set out in Sections 41(3)(a), 41(3)(b), 41(3)(c), 41(5), and subject to the exceptions in Sections 41(6) and 41(4). First key argument. The Court of Appeal misinterpreted the application of the Youth Justice and Criminal Evidence Act of 1999 to this case. At the heart of the application of Section 41(3) is the ideological relevance of a given piece of sexual history evidence. Here is the test of the probability with which such evidence can validate a disputed fact among the many other pieces of evidence at play within a case. The evidence from O and H that the defense sought to adduce was not particularly important in establishing whether there was consent by X, or a reasonable belief in consent by E. This is because although X had consumed a significant level of alcohol, she still could have consented. In the case of R versus Bree, drunken consent is still consent. Likewise, it is also plausible that E could have reasonably believed in X's consent despite her apparent level of intoxication. Again, in the case of R versus Bree, once a complainant consents, that consent cannot be subsequently revoked. In the original trial, the jury had heard expert testimony from the defense that questioned X's claim about memory loss given the level of alcohol she had reported consuming. This suggests that E and M's claims of belief in her consent would have already have seemed reasonable to the jury, thereby rendering O and H's evidence unnecessary. The defense argument will likely focus on the Court of Appeal's reasoning that the complainant's prior sexual behavior with H and O injected sufficient reasonable doubt around E's belief in her consent. According to Section 41(2)(b), even when she fits into one of the gateways, it should be excluded if its probative value is negligible, as is the case here. On this base, the she should have not been admissible as it was not needed. Second argument, the Court of Appeal erred in its reading down of Section 41 within the ambit of Section 3 of the HRA 1998. If Section 41 is incompatible with Article 6, then it is not feasible to then interpret the section to achieve consistency with the article. Section 3 of the HRA imposes an interpretive obligation whereby domestic courts are required to interpret legislation and prior case law in a manner that is consistent with convention rights. However, Section 3.1 does not grant courts the authority to set aside the language of legislation or disregard its intent. Instead, it requires courts, where possible, to do so, or where the provision in question is ambiguous, to assess whether legislation is interpretively compatible with convention rights. Defense counsel will disagree. They may claim that Parliament's focus on protecting complainants gives rise to an inherent imbalance within Section 41 that comparatively undermines the fair trials of defendants. They may assert that courts are therefore obligated to correct the imbalance, and to do so, Section 41 must be interpreted to be consistent with Article 6. This was the case in R versus A, where Section 41 was found to be overly restrictive. Article 6 is not the standard of law expected, but instead is the lowest common denominator on which jurisprudence should be based. As such, courts are not authorized to substitute or revise legislative text, or to rule in a manner that subverts parliamentary intention. This is especially so in the case of Section 41, for which the language of the legislation and its intent are abundantly clear. Article 6 is one of several qualified convention rights. These are the rights that states can justifiably breach in circumstances to balance individual and societal rights. Third argument, the Court of Appeal's decision to expand the scope of Section 41(3)(c) undermines public confidence in the administration of justice. As expounded at length by Lord Hutton in the case of R versus A, the law, specifically in rape trials, must ensure that complainants are treated with dignity and spared from the introduction of and/or cross-examination of evidence that is not unnecessarily harmful, humiliating, invasive, and intrusive. Rape and other sexual assault crimes are uniquely personal and constitute invasion and violation of a victim and complainant's person and space. Intrusive questioning about or revelation of the most intimate details about their lives are often traumatic. Some complainants even liken the experience to reliving the original violation. This is likely to deter victims from coming forward, as borne out by British crime survey data, which shows that less than 10% of rapes are reported and that an even lesser amount is prosecuted. Further, as noted in the 2021 Law Commission report, the number of prosecutions of sexual violence offenses have also steadily declined over the past 5 years. This points to a system that is not protecting victims. The defense sought to adduce evidence, as in the case of R versus T, that showed similarity between X's sexual behavior with O and H to that with E. The inference being that previous consent to similar behavior is indicative of consent in the current instance. As Lady Hale affirmed in the case of R versus C, sexual relations are uniquely person and situation specific. There is no such thing as a generalized consent to sex. Further, as Justice Gontier observed in the Supreme Court of Canada case R versus Dirac, consent must be given for each instance of sexual activity. Therefore, the fact that X had previous a similar sexual interaction with O and H was irrelevant to her interaction with E. Since O and H were not present at the time of the alleged incident, at best their respective accounts speak only to probability. Further, in keeping with the balance of harms principle that underpins retributive justice, the ensuing harm to the complainant's interests and the prejudicial impact of the evidence fails to justify its admissibility. By allowing the admission of she, the Court of Appeal decision in this case perpetuates the twin myths that Section 41 was intended to discourage. It conflates consensual and non-consensual sexual activity and distracts from the truth finding that trials are meant to facilitate. As demonstrated, the probative value of the sexual history evidence adduced in this case was minimal. In its reading down of Section 41, the Court of Appeal diluted parliamentary intent of the legislation, and adducing she in this case undermines public confidence in the administration of justice. On the basis of these arguments, this appeal should be successful.